Welcome, fellow commissioners, staff, and members of the public to the fourth meeting of the Columbus Charter Review Commission. Hard to believe we're into our fourth meeting already. We're having so much fun as we go. First thing we need to do is to seek approval of the minutes from our prior meeting on May 7th. You all should have received a copy of those minutes. I have a few corrections of my own, but before I get to mine, I'll ask other members if they have corrections or additions, and if they don't cover mine, I'll give mine.
I have a couple to offer, but they're more grammatical, et cetera, which would be in your field far more than mine.
I'll go first, then, if you'd like me to, and they are all in the nature of editing, spelling, and grammatical changes. On the page 1, second to last line, the word statics should be statistics. On page 2, second paragraph, second line from the bottom, the word should be fundamental rather than fundament. Same page, 3 paragraphs down from that, which would be the third paragraph from the bottom, we refer to the experience of other cities who have. It should be the experience of other cities that have. On page 3, third paragraph from the top, publicly is misspelled. We don't need an A and an L in there. And same page, fourth paragraph from the bottom, we just left out the word the. It should say Mr. Curtin asked to entertain the thought. Not that I'm above leaving articles out from time to time in my speech. I try to be more precise in my writing. And members of the commission, I think those are the only changes I caught, all of which, as I say, are grammatical or spelling in nature. Mr. Doran, any others?
Nothing more to add.
Any other changes, additions, corrections?
Move approval of the minutes of May 7th as correct.
Have a second?
Second.
All those in favor?
Aye.
Minutes are approved. The next item on our agenda is to receive a summary of public comments received since our last meeting on May 7th. And Brian, I presume that's you?
Actually, the clerk will provide that.
Andrea?
Yes. Thank you very much, Mr. Curtin and members of the commission. We have three comments to summarize for you today, or 3 commenters. On May 19th, we have a comment regarding the subject of council composition, public meetings law, and rules for speaking before council. On May 18th, we had another commenter. We will call for purposes of today commenter number 3. Their subjects were council composition, public meetings law, rules for speaking before council, and campaign finance laws. And on May 21st, commenter number 4 commented on council composition. And copies of these comments are reflected in your packets. Thank you.
Any reactions or comments on the submission of public comments to date from any of the members? And we are on to a report from the administration on several issues, the first of which are utilities, public utilities, which would be sections 118 through 124 of the charter. And that's going to be from Mr. Davies.
Thank you, Co-Chair Curtin, members of the committee. My name is Greg Davies. I'm Director of Public Utilities, and really our changes are just housekeeping, pretty minor, and just coming up with the terms that better suit us in this day and age. And we had, as we always do, lots of input from Auditor Dorian, who assisted us on many of these changes. So just quickly, the overview, and then I will give you the recommendation and answer any questions you have. Currently, sections 118, 119, 120, 122, and 124 reference terms such as waterworks, water service, water debt, and water department. This terminology does not reflect the full services of our department, as we also provide sewer services and electricity services. In addition, sections 118, 119, and 120 do not adequately describe the funding mechanisms utilized by the department, and sections 121 and 123 are no longer reflective of current times and are no longer applicable. Our recommendation would be that the applicable sections be updated to change the water-centric references to reflect the mission of the department. Water references will be updated to utility and/or utilities. We recommend that the applicable sections be updated to include debt obligations and interest as a part of the cost of service rate calculations. And additionally, based on the guidance that Auditor Dorian provided, we recommend that sections 121 and 123 be stricken. And finally, it is recommended that section 194 be updated to reflect common business practice that would prevent unjust discrimination in service or rates should the utility allow a franchise. And that is all of my comments, sir.
We might start with asking Commissioner Dorian to provide us with some reaction from.
Thank you, Chair. First of all, I concur with Mr. Davies' comments in regards to all those sections, but I'd like to add a couple of comments regarding Section 121 that speaks to a depreciation fund. There was a time when depreciation was certainly a key measurable factor, and we continue to measure it to this day, not only in water, but in sanitary sewers, electricity, storm sewers, and so forth. The Section 21 subparagraph A speaks to a sufficient amount shall be transferred to the trustees of the sinking fund at the beginning of each year to provide a sinking fund for the redemption of outstanding water bonds at maturity. And then paragraph B says the residue after making such a transfer shall be applied in the making of repairs, extensions, or replacements. Well, the fact of the matter is your debt service, your payments on bonds and interest are more than double what the amount of depreciation is on any of these utilities. So if in fact we followed this charter section to the T, we'd pay less than half our debt. So I'm suggesting that it simply be deleted, and depreciation is always calculated and considered annually, but it does not play a role in the calculation of rates. What does play a role is the full payment and obligations of your debt. So again, I say if we were to follow this Section 21 as written, we'd only end up paying about half our debts. So I am suggesting that that is no longer applicable, won't work. I'd like to also comment on Section 123. 123 talks about deposits made by water customers, and if you'll notice the word may is used here. Well, I don't think there's been any water customer deposits for the past 15 years or more. And of course, one of the more onerous things here is that if such deposits were made, and by the way, there still are some electricity deposits, they call for a payment of 4% interest on them. Well, I wish I could gain 4% interest on anything we're investing for the city these days. So 2 points. Quite frankly, there are no more cash deposits on water or sanitary sewer or storm sewer. And I clearly, if there were to be some, clearly would not want to have to pay 4% interest on them. So again, I suggest that 123 be eliminated. If the need for that ever arose at some future time, council could enact it in their code and establish a more reflective interest rate if they chose. So my suggestion is 121 and 123 are no longer workable and should be deleted. I'll be glad to answer any questions.
Questions for Mr. Davies or Mr. Dorian? I have one, Hugh. Are we safe then, should this commission recommend these changes to council, and should council agree and forward these proposed changes to the electorate, are we all safe in saying that there would be no substantive change to how business is being conducted today?
Yes. Yes. Yes, clearly, yes.
It's merely a matter of antiquated provisions which haven't been followed for some time being finally stricken.
Well, as I say, if we followed those provisions, we'd only be paying half our debts. So the focus is, and Mr. Davies correctly recognized this in the section that speaks to the establishment of rates. Prior to this time, you didn't see anything calling for the recognition of debt obligations being covered. The sections continued to talk about covering interest, but not your principal. So that's why I support the recommendations of Mr. Davies and go a step further and suggest we eliminate these sections that are simply not being used, not workable.
Mr. Davies, any reaction to the auditor's comments?
No, just that I completely agree with them, as always.
Well, we have discussed these things to make sure.
Yes.
We're shocked to learn that. Any other reactions from commissioners?
About those sections in particular?
About those
or
sections.
generally? Not about those sections.
One question I would have, and this is reflective of Commissioner Cabot's comments at our last meeting, what would be the process for us notifying the public that should the commission today vote in favor of recommending these proposed changes, what would be the process that we would go through following that vote?
Right. I can speak to the council process and would leave it to Sherry or Director Davies to the administration process. Obviously, council would have to act by ordinance to place this before the voters. It would be placed in the city bulletin. Council would hold hearings on this particular issue, and then voters, if they chose to support this, would see it reflected on their ballot. So those would be from the council perspective, the public notifications, in addition to the notification of our tentative and final agendas.
And then obviously, before, if you guys tell us today you're okay with us moving forward, we'll be bringing back at our next meeting or the meeting after that new language for you to officially vote on to move forward through the process, so the public would get it through your process of actually looking at the language and then vote on it. And well, before that, Brian's step, and then voting on it. And I think that because this is really reflecting what we do today, there really wouldn't be a change to the public in terms of how it plays out for them in the future.
So the question before us is whether someone wants to make a motion to charge the staff with putting this in the proper language and bring it back to this commission. Is there a second?
Second.
All in favor?
The only comment I would make, I thought at the last meeting we discussed holding off all final recommendations to city council until the end. So I'd like to see language at the next meeting, but I thought we decided we wouldn't take any votes to make formal action until the end after we had put it on the website and given the public an opportunity to see all the proposed changes before we made our final recommendations. Is that what was discussed at the last meeting?
I agree with that. I think it would be very helpful to me to see somewhat of a synopsis as we draw it to a close here.
Yeah, that's consistent with, that's consistent with my comment last time and the concept that once we think we've got a final piece of proposed wording, that it be out there on the website for a while before we actually vote on it. So, yeah.
Okay, so we're on to the sinking fund.
So, I'm sorry. So the utilities, you don't compete for the most part except in the electricity arena.
That's correct.
Is there any special language that you're going to propose or talk about that's kind of a unique instance. So is there anything that, and maybe the charter's not the place to address things like that, but I just asked the question. I asked the question because yesterday I heard that Columbus City Schools are in the process of transferring most of their schools from City Electric to AEP because AEP charges them less, and I'm just curious about things like that.
I guess, and I apologize, I don't fully understand the question. Are we going to put something in the
You know what? You make a good point. It's a rambling question that doesn't have a point.
I didn't say that.
I just was curious that, again, because in one of your utilities, you compete with the private sector, in the others you do not. Is there any need to specifically address that particular instance in the charter, or is that left better to the day-to-day management and the council ordinances and that type of thing?
Commissioner, I think what you're speaking to is addressed in section 124 of the charter currently. It's on page 3 of Director Davies' comments. In relevant part, it says, except that any such service furnished in competition with a privately owned plant, the rate shall be such as, in the opinion of council, tends best to develop and increase the business, to increase the load factor, and to promote in other ways the general success of such utilities.
Thank you. Any other comments or questions about the utilities section?
I do have a clarifying question on section 122, if I may, Mr. Chair. I'm sure we don't want to get into the practice of wordsmithing, but it strikes me in section 122 that asylum may no longer be the politically correct term, and perhaps consider revising that. And then I had a clarifying question about the language that follows that: charitable institution devoted to the relief of the poor, the aged, the infirm, or destitute persons or orphan children. Is this something that those organizations access currently?
No.
That just caught my attention, and I'm not necessarily recommending that we strike it, but I just wondered if that was something that is utilized.
Sure. I'm sorry.
No, it's okay. I'm finished.
Our typical process, if any of those institutions ask for relief from a water bill or sewer bill, we do not do that, but we will work with the development department and the programs that they have or agencies that they're in touch with to make us whole on the cost of the water and sewer. We obviously have a 20% discount for those that qualify based on income, and we have a discount based on age. But in terms of anybody actually applying for free water or sewer, we would not do that without another department or agency paying that bill. Does that make sense?
Commissioner Tyler's point is well taken. If this isn't already in the list of things that the administration and council were discussing in terms of modernizing language, obviously this should be added to this discussion. Any other comments or questions about the utilities section? If not, we'll entertain a discussion on the sinking fund.
Good afternoon, all.
Good
I guess I'll
afternoon.
take as my introduction. My name is David Irwin, and I am the secretary of the sinking fund. And after speaking with Sherry last week, and I've spoken with Mr. Dorian about, with regard to the sinking fund charter sections, I thought today would serve more as I'm looking at your outline, an overview of the sinking fund, because probably not a lot of us here, other than Mr. Dorian, know what the heck a sinking fund is. So I guess I was looking at it from my perspective. I should be more of an educator here today. And I brought with me a few items, and I didn't realize there were going to be so many folks here at the table. I just brought five outlines for the commission members. So if you would please pass those among the commission members. And I thought I'd follow that outline a little bit.
That was derelict in not pointing out that we're talking about sections 133 through 141.
Correct. And as you may be aware, sections 133 through 141 relate to the sinking fund. I don't know if you want to go section by section, just to talk about things, and then I thought what I could do, and again, Mr. Dorian can relate to this, speak of how debt service was done in the past, how we do it currently, and looking forward into the future. because believe me, things have changed dramatically. Yeah, I've been with the sinking fund for 19 years. And in those 19 years, things have changed dramatically as to how we handle debt. And the sinking fund is charged with payment and administration of the city's debt service. And that's spelled out through charter sections 133 through 141. I am not a city employee. I'm probably the only person here in this building wearing a badge who's not a city employee. I'm an employee of the sinking fund. We're in an autonomous creation of the city charter, and I do not work for the city of Columbus. I work for the Sinking Fund Commission. I work at the pleasure of 4 board members that are appointed by the mayor to 4-year terms. And again, this is spelled out within the charter. And again, I defer to Mr. Dorian, and I know a lot of you do too, for his expertise. He's my mentor. These sections of the charter, I believe, were done years and years ago, Mr. Dorian, in order to eliminate any political influence, any funny business, so to speak, with regard to payment of debt service. I had a former boss who used to say, you gotta pay your rent money first. And that's basically what we're doing here. The city owes money to investors when they issue bonds. Our office pays that bond principal and bond interest as it comes due. That's about as simple as I can make it. But with that being said, I think it might be helpful to kind of walk you through the process of how things have evolved with regard to the sinking fund. And I'm not surprised that I'm here today speaking with you, because I'll be the first to tell you that there probably should be changes made to the charter with regard to debt service and the administration of debt service. And I think I might share that same view with Mr. Dorian. So if I may, I'm going to kind of jump backwards to debt service in the past, and I've actually brought a few items along with me, and again, Mr. Dorian might relate to these things. This piece of paper right here, this is a bearer bond. Okay? That's how bonds used to be issued. Okay? This piece of paper right here, we'd get hundreds upon thousands of them. Signed by the mayor. At the time of this bond was issued, Tom Moody and Honorable Mr. Dorian as auditor. And this would be for a specific purpose. In this case, this was a bond for the municipal airport when the airport was under the city of Columbus. And attached to the face of that bond would be these teeny little coupons.
Found some of those in Grand Aunt Nellie's closet.
Yes, and again, for a lot of you, and for me, when I first started working here, I read about bearer bonds and coupons when I was in college. I never knew what the things were until actually working with them and seeing that. And I think even the term clipping coupons comes from years ago. Your parents and grandparents would actually clip those coupons every 6 months from the face of the bond and send them in for redemption to pay the interest. And as you can see, this is just one $5,000 bond. And if you have an issuance of greater than $1 million, you do the math, 1 million divided by 5,000, there's a lot of bonds that have to be physically handled. And years ago, when I first started working for this office, that's what we did. It was a constant flow of this type of minutia that came through our office that we would have to account for. And these have been canceled out, so they're not live securities. But this essentially is cash. Prior to this being canceled by our office, this is cash. And again, I defer to Mr. Dorian's expertise that I think that might have been part of the bigger issue when we changed from bearer securities to what I'll speak to here in a moment. The problem with this is it's very untraceable. And we as the sinking fund, when someone walks in our door and says, here you go, we have to pay. It says clearly on the face of the bond here, you have to pay the bearer of this certificate, the amount of monies that's due. So I'm just going to lay that on a table for right now. That's how things were done in the past. Well, we no longer have any outstanding or bonds of this type that are coming due. The last time those maturity for those types of bearer bonds was in 2009. Beginning in the early 80s and up till today, bonds are now issued. This is one bond right here for $3,740,000. That's actually kind of small. That's not a large amount. And this what's kind of interesting. I find it interesting. You can see how awful looking this thing is. You know what happened to this? It was damaged in Superstorm Sandy. Remember that a couple years ago? Because all these bonds are held in New York City. They're held in a depository in New York City. It's called the Depository Trust Company. And you can see this thing is, rust marks where the staples were. But when this bond comes in, this is a bond issued in January of 1998. It was due May 15th, 2014, a week or two ago. It's for $3,740,000. If I had to do it in that manner, we would have had 748 bonds to deal with, stacked that high, along with all the coupons associated with those bonds. It's just a lot of physical manpower that's required. And nowadays, we get this. I make a little remittance device to the treasurer's office, right next door to my office, and the treasurer will wire $3,740,000 to the what's called the Depository Trust Company in New York City. They are then responsible for moving that money to whomever is the owners of those bonds. I don't know who they are. Mr. Dorian does not know who they are. We don't care. We're just required to make that payment to the depository, and the same thing is done with the associated interest on this bond. Same thing. On May 15th, I would have made a separate remittance advice to the treasurer, telling them that X amount of bond interest is due on this particular bond issue, and they will wire the principal, they'll wire those interest amounts. It's done. Simple. Versus this right here. And what the other interesting thing that with regard to bearer bond debt service is that, as you can see from this piece of paper I brought here, this was a bond that was due in 2004. $5,000 due on the first day of May 2004. It was sent into our office in August 2012. So you think, that's over 8 years has elapsed since the maturity of that bond. Our office received the debt service payment for that bond through Mr. Dorian's office in May of 2004. It was not paid out until August of 2012. Well, that's how this office has been able to operate since its creation, is basically through float. We the sinking fund invest monies that aren't the debt service monies that are paid to us by the auditor's office. If bondholders don't redeem their obligations on a timely manner, the sinking fund invests that money, and that is one of the things spelled out within the charter. I'm kind of hopscotching around here, and I'll try to follow my outline as best as possible. So we also have a very small investment portfolio, not unlike the city treasurer, who invests millions upon millions of dollars. we have a small investment portfolio, about a little over $1.5 million, held mostly in UST bills, and we also hold some city bonds issued by the city of Columbus, where we are the actual paying, or we are the customer that is, in a sense, holding that bond. Up until last year, the float that we have earned on investments not being redeemed timely have paid the administrative expenses of the sinking fund. There were, at the time I started working, 3 employees of the sinking fund. There's now just myself. And because of the dramatic fall in interest rates these last several years, and expenses have been, gradually increasing, my salary and such, interest earned has just fallen dramatically. So we've now come to a point in time where I have had to ask the City of Columbus to fund our operations. That's just something I speak to the fact that I'm not a City of Columbus employee. However, operational expenses for our office are coming now from the City of Columbus.
Where's your office housed?
Downstairs. Yes, and it's been there, I've been in the same room for 19 years. I'm right down at the end of the hallway, right next door to the treasurer. Across the hallway is a part of the auditor's office. I physically have just one room.
What are the annual operating costs of the sinking fund?
It's myself. I'm the only employee, so it's essentially my salary, and I mirror the benefits of any other City of Columbus employee. I'm a member of PERS, so obviously the sinking fund has to pay a portion of my PERS contribution. My insurance is through the City of Columbus. Workers' compensation premium is an annual payment that I must make. What other things? Just incidental, office supplies, any capital item, a copier, desk and chairs. So the incidental expenses of the sinking fund are actually a part of a budget process that I go through that is, again, spoken to in the sections of the charter. I am required to prepare a debt service budget that is due on the 1st of May each year. And this debt, I only brought one, I'm sorry. This debt service budget, it's not very interesting reading, but it spells out the debt that is, in this case, coming due in current debt that's coming due in the year 2015. And I give detail within this budget document of how much debt service is coming due in 2013, excuse me, 15, a little over $329 million. And in addition to that, there's going to be a small line item here which says sinking fund administrative expenses. In this case, $132,000 and change. So the amount budgeted that must be budgeted for 2015 is a little over $329 million. And this is a document that I have to provide to the council and the clerk. I think, Mr. Doran, you can speak to what physically is then done as far as, I think that the county has to certify that debt. Okay. So I guess what I'm getting at here is that in the past, we've had, as I've shown here on the table, physical documents that have to be handled, processed, and we used to have the staff to do that. Now we do it this way. It's a lot easier, less cumbersome, very little paper to deal with, and it's basically a lot electronic transactions that move money from us to a third party who then distributes the money to the debt holders. Makes things very simple. And I am responsible for making sure that those debt payments are made. I keep copious records with regard to debt service. However, Mr. Dorian's office is keeping the same exact records that I am. And it's nice to be able to make sure that, you know, there's a checks and balance there. And I think, once again, that was the crux behind creating this city charter, is that there is a checks and balance mechanism for payment of debt service. There's not going to be no funny business with regard to debt service. It's done without any political influence. And if you're asking me at this juncture, I would say that you know, it's come time to review the city's charter sections with regard to the sinking fund. And
Mr. Irwin, since you're not a city employee.
Yes.
Who holds you accountable and who does your job performance review?
I do not. Well, I guess my job performance review would be that I get paid every 2 weeks. I work for the trustee. I work at the pleasure of our 4 trustees appointed by the mayor. I meet with them on roughly every month, every other month during our busier seasons, which is the tax or the annual report time, which is January through April. We meet every month, and at that time, we take voice votes on you know, the activities that have been done throughout the course of the month. But to answer your question, I work at the pleasure of the board members, and I meet with them on a monthly or bi-monthly basis.
I don't think anybody around this table would have any doubt that the city auditor is looking up your tailpipe all the time in terms of
Yes.
what you're doing, but in terms of organizational structure and review of your job performance, would that be the job of the 4 trustees,
Yes.
I presume?
Yes.
Okay, and do they have any formal process for judging your quality of your work?
No, I have not physically received a job performance review in the time I've been as secretary of the sinking fund, and I don't miss it. If that's the right thing to say. Each year in April, the board discusses my salary and benefits package, and again, they try to follow lockstep with what the city of Columbus does with regard to its employees. And as I said, I work at their pleasure.
So I've often heard Mr. Dorian referred to belt and suspenders. I'm wondering if a sinking fund mechanism isn't belt and suspenders and maybe even something else. I'm wondering if other organizations, other cities, other political entities all have sinking funds, or if it's kind of hit and miss.
Yeah.
I'm wondering if it's an anachronism of another time. And I wonder, does our Moody's and Standard & Poor's and Fitch ratings benefit from having a sinking fund, or does it make any difference to them? Those are a bunch of questions.
Well, yeah,
Much like I asked
think
Mr. Davis.
I may defer to the belt and suspenders over here.
Well, I learned that belt and suspenders from Dan Drake, by the way. First chief city attorney for many years. Let's see, where shall I start? The belt and suspenders, the checks and balances in this city today regarding debt are the Department of Finance and Management, the legislative body, and the city auditor, overseen for legalities by the city attorney. I've often said that I think Columbus, Ohio, and I really want to jealously guard this, has a wonderful separation of powers. When we think of, you want me to proceed?
Thank you.
I rarely ever get a question about the sinking fund. We are unique. We are unique. You'll remember a meeting or two ago, I asked the question of the city attorney, if a charter amendment were to pass that eliminated the sinking fund, or could it be in a prospective manner? Otherwise, if the vote was November X, I don't want David disappearing the day after November X. But I think prospectively, because there would be some administrative duties involved to transfer. Let me put some of these things in perspective. David, by the way, is a stellar alumni of the city auditor's office many years ago. That been 19 years, David? Jeez, I can't believe
Just in
it.
the sinking fund, yes, I'm approaching 30 years of service.
Anyway, the city of Columbus has outstanding bonds and notes today of about $3.7 billion. That number will soon be $4 billion when we complete our next bond sale. The debt service on all of that debt, as David mentioned, $300 million plus goes through his office. But there's more because, well, we have revenue bonds. David speaks primarily to general obligation bonds. When we think of this debt, one of the things that makes Columbus safe and secure, and as you know, a AAA-rated city, about 2/3 of that debt pertains to water and sewer facilities. Sanitary sewer is, not quite half, but closing in on half of the debt. All of the city's debt is for infrastructure, capital. City of Columbus does not borrow money to pay its utility bills or its operations, unlike when you see cities that begin that process, you can count on them getting into trouble sooner or later. David mentioned the sinking fund has an investment portfolio of $1.5 million or so, David,
Correct.
Approximately.
Correct.
The city's investment portfolio today is $1.6 billion. What's the check and balance on that? Forgive me for saying but I've kind of written that code over the years. It's managed by 3 persons representing 3 different sections of government. The Director of Finance and Management works for the mayor. The city treasurer, who is appointed by the council, and the city auditor. So you have 3 branches in effect who manage that. When David talked a great deal about the bearer bonds. Bearer bonds were eliminated and outlawed by the IRS in 1983. The last bearer bond was issued in 1983. Ever since then, by the way, Columbus was one of the first cities in the nation to start issuing bonds through the Depository Trust Company. I can just a little anecdotally, I can remember one year under bearer bonds having to sit in the basement of a bank and sign over 7,000 pieces of paper one day. But today it's you don't travel to New York much anymore to do things. Everything is electronic and facsimile and so forth. I'm sure you're all familiar with that. But in the case of the sinking fund, when the sinking fund gives money to the city treasurer and the treasurer wires it out, think of where the sinking fund gets that money. The money, first of all, comes into the city of Columbus, either through income taxes or water bills or sewer bills or so minimally anymore, property taxes. There was a time back in the 80s when a part of the property taxes, a small part, was used to pay debt. We don't do that. Haven't done that since the 80s. Haven't done it since the 1982 income tax rate increase took effect. And that weaned off, and I think 1985 was probably the last year we used property tax. So the sinking fund is sitting there. They're a pass-through agency. The money comes to the city. We give the sinking fund money. Sinking fund tells the city treasurer what to do with it. The treasurer wires it out. Some of these duties you will not eliminate. What my quest here is, if I can use the word, maybe a little added efficiency in governmental services. I can see the city, like virtually all cities, I hesitate to say all, vast majority, counties, et cetera, you'll have an outside paying agent, a bank, handling registration of, there are a few remaining registered bonds from earlier days, I'm sure, David. And those duties are typically farmed out. And I will tell you, one of my concerns about this relationship is there's only one David Irwin. And the role the sinking fund plays today in authorizing documents for debt is critical. And I'd rather, quite frankly, I'd rather see that contracted out to an ongoing establishment, take bids from, there are only 3 or 4 banks that even do those services anymore. But that's what I mean when I say you would not eliminate all the duties. But I'm concerned about the continuity of the sinking fund. And we could, in fact, the checks and balances will still be there. Administration, believe me, I'm happy to say that in my career, I've always worked very, very closely with the Department of Finance, today Department of Finance and Management. I think that's the only way you serve your citizens, and I'm serious about that. So I see this as an opportunity, and by the way, I've had similar conversations like we're having now with bond counsel and financial advisors and so forth. I have not specifically spoken to the rating agencies on this subject yet. I've not done that. I do not anticipate it to be a problem, but I want to be clear, I've not directly talked to them on it. So I see an opportunity for Columbus here to add a bit of efficiencies, cut out some duplicated services today, and then ensure the continuity of those remaining duties by contracting with a financial institution to do so. So my recommendation is that we proceed to eliminate the sinking fund from and all references to it from the charter. But I do not want to do it the day the charter passes. I would like to put a prospective date of, whether it would be 6 months, 9 months, something of that nature, to make sure collectively, when I say collectively, Department of Finance, the Auditor's Office, Treasurer's Office, and Mr. Irwin assure ourselves that we cover all the administrative duties. So that's my thought process on this.
And if I may dovetail on that, I wholeheartedly agree. And does that mean I lose a job? I don't know, but its time has come. And as I've discussed with Mr. Dorian, this is an opportune time to make changes in the charter to eliminate this. I don't feel its role is as critical as it was 20 years ago.
Well, let me add to that, your comment, David. I've already talked internally in my office. I said, next year's budget, find out what David Irwin makes. I want to add that to my budget, because if this thing passes, I want him on board to help us get through it all. So don't worry about the job, David. We'll get it.
I appreciate that. Yeah, I do echo your sentiments, and that there's a need for change with regard to the sinking fund.
I'm assuming that this whole issue has been well vetted with the city attorney's office, the administration, and council, and there's no anxiety over us moving down this path.
I do not want to represent that I have vetted this completely with the city attorney yet. We've had conversations with finance and management, conversations with Mr. Clark and so forth, but I want to be very careful about my representations here. I've not sat down and vetted it completely. Brief comments back and forth with the city attorney's office, but don't want you to think I've gone through every word of this yet.
Questions of Mr. Irwin, Mr. Dorian, or staff?
I just have one question, make sure I understand what's being proposed. The administrative functions that will remain will be outsourced to a financial institution, and then are there other functions that would just be absorbed by the city auditor's office?
Functions that we're already performing.
Okay.
The auditor's office, the treasurer's office, Department of Finance's checks and balances. The treasurer is the treasurer for the whole city of Columbus. She wires money, I don't want to say every day of the week, but let's say quite often. So we'd outsource this duty of paying agent registrar, transfer agent, that type of thing. But the other duties would be absorbed in-house.
And those are duties I'm performing really concurrently with the auditor's office as far as debt tracking, a particular issue, the auditor knows that, this particular issue matured on May 15th, 2014. And I had 3-4 weeks previous sent them an invoice, so to speak, saying, hey, May 15th, this is what you need to pay by May 15th, this is what you need to pay our office so that we may wire those funds via the city treasurer's office.
So the efficiencies that you speak to will be because of the work is largely duplicative?
Yes.
Okay.
Yes, absolutely.
Thank you.
Absolutely. Yeah.
Mr. Dorn, you made reference to fewer and fewer financial institutions offering the type of services that you would contemplate outsourcing. Would there be a day when maybe there'd be 0 financial institutions offering those services? And if so, what would be the recourse for the city then?
Well, the recourse is to take it back and do it ourselves. But there's a fee for this. I mean, these financial institutions, they're not, may get philanthropic after the P&L is concluded, but not until that time. So there's a fee involved, and no, I don't foresee it going away.
You don't see that being an issue of concern?
No.
Well, I don't know if a motion is in order, but I would move that we ask the various staffs involved in this to propose language to modernize the sinking fund, and if there's any remaining language that needs to be in the charter, tell us what it is and where it should go.
I'll second that motion.
Participate, along with David.
We have a motion and a second. Any other discussion before we ask for a vote on that motion? If not, all in favor?
Aye.
Thank you. We look forward to some scintillating language on the sinking fund.
And all of you can look in your grandparents' safe deposit boxes for those little things that you probably didn't know what they were, but now you know.
Do you want this back?
Yes, please.
Next item on our agenda is a discussion of public records and open meetings, an overview of state law. Is that Mr. Cox?
Yes, Mr. Chairman. Thank you. This will not be nearly as scintillating as the sinking fund, but
I never heard the scintillating word used with the sinking fund.
and you probably never will again. Unlike the sinking fund, however, I think most of the folks at this table have, and if you've ever worked in a public office, are already familiar with public records and open meetings. So this will be very general. I think the key point here is that both public records and open meetings are creatures of state statute solely. We are not subject to the Freedom of Information Act, which is applicable only to federal agencies. We are subject to state law as it relates to public records and open meetings, and those are found in primarily two places. Public records is dealt with in primarily 2 sections, Section 149.011, which defines what a public office is and what a record is. And basically a record is any document, device, or item, regardless of its physical form or characteristic. And it includes electronic records, as we discussed previously, that documents the activities, functions, organization, policies, et cetera, of the public office. So then you go to Section 149.43, which lays out in pretty extensive detail what is accepted from that definition of a public record, what the process is for making a request, what the public office must do in response to that request, what the remedy is in the event that there is a dispute as to whether there's been a correct response to that public records request, the remedies for a breach of the requirements under that section, and other miscellaneous items such as training. Trying to think what else. how to deal with bulk commercial requests, et cetera. So that's a fairly extensive section, so that's where you find most of the information on public records requests that the city deals with daily, and our office deals with on a regular basis as well. Probably less frequently are issues related to open meetings. The open meetings law is found in section 121.22 of the revised code, and it applies to all agencies, both state and local government, with the exception of the General Assembly. I don't know how that happened, but it applies to the city and all the decision-making bodies of the city. Based on the city attorney's advice, it also has been applied to our non-decisional bodies that are advisory, such as area commissions. And that, again, that is found in state law as well. So those are the two areas that address both public records and open meetings. Again, those are applicable by operation of state law to the city, and we have no authority to create exceptions that are not provided for in state law to both those, both public records and open meetings law. Have any questions? Yes, sir.
Are there any mentions or sections of the charter that are in conflict with or inconsistent with the state laws?
No, the only,
Don't speak to it.
no.
Okay.
The only issue relating to open meetings that was the last time we had a charter review commission dealt with meetings of council, and just added language that said it's the general law of the state is applicable to meetings of council as well. And that provided essentially for executive sessions, which I think has happened once since that
Because there
was
wasn't a charter
amended.
provision for executive session, was there?
I'm sorry.
There wasn't a charter provision for executive session, right, okay.
Any other questions?
Can I make a general comment? And thank you, Mr. Cox. When we talk about this is, I want to emphasize general comment. I'm not casting concrete on this. But when we talk about amending the charter, whether it's public records, ethics, equal rights, et cetera, I'm sure every one of us is all in favor of supporting these things. I'd like to see the charter, to the extent possible, just emulate the state code and not necessarily add a lot of language that could in fact be misinterpreted. Once it's in the charter, it's there for a long, long time. And what makes me think of that is, was it 2011 or 12 when the executive session permission for council was on the ballot? And I was on that committee, and boy, there was a lot of dialogue and a lot of debate on it. But everybody agreed, and the voters agreed and accepted that if we just made it like the state code, they found it very acceptable. So that's a general comment of mine as we approach all these things. I think there's a lot of merit to saying, hey, the state code is universal through the state. It's already been established, hopefully tested and proven at this point. So I kind of like the idea of us emulating the state code in our charter, but that's just a general comment for all these things.
And just to amplify, emulate, you don't necessarily mean repeat, you mean refer to.
Yes.
Because the state code does get changed from time to time, so yes. Okay.
Yes, thank you, Jack.
As it relates to that particular amendment, if we had not had a provision in the charter that talked about meetings of council being open, that amendment wouldn't have been necessary because the general law of the state would have applied.
So we've had conversations in previous meetings about documents, what form the documents should be available in, whether they are permanent records, all those things. If we just refer to state code in relation to open records, schedule of record retention and things like that, we'd probably be on safer ground than trying to say specifically within each case, this is a permanent document in this format for whatever time, or something like that.
That's my general thought
Yeah.
process.
I think for those couple sections that we brought up for you. I think that we heard you, that you would like to see those be more permanent, so we are working on specific language for those specific sections and those specific documents. But I think the administration agrees if we were to add anything about public records or open meetings, that referring specifically to the state law would cover us.
Just adding to Hugh's comments about, a general comment here. My primary goal in this area would be to make sure we do no damage. We do nothing which is a diminution of what has been the historic sense of the charter, and that we honor the spirit of the charter's founders, that the fundamental documents of the city be readily available. That's why I was a little bit affixed on permanent record, because it's an electronic age. A lot of lay people don't think of electronic records as being permanent. So my chief goal as a co-chair would try to make sure we, in medical terms, do no damage, do no harm to what has existed in our history in terms of this presumption of openness. But I'm sensitive to the city auditor's concerns and the city attorney's concerns and any other concerns that we not enact language that could have unintended consequences in terms of hamstringing the city through subjective reason about what was meant here and so forth. So I would look forward to some language from staff that would demonstrate that the charter wants to honor its historic presumption about things that would be open to the public and be, of course, in conformance with state law as it evolves.
I would like to add one thing on open meetings. The one other area that the legislative body and Brian and I have talked about, and the administration that we've talked about a little bit with Mr. Cox, has been that the area commissions, as Josh mentioned, they've given us an opinion saying that these non-advisory bodies could be public bodies. We may want to make that a little bit more firm to say if we created another charter review commission that they would be considered a public body and that those would be public and open meetings. Also, another example would be we've had an accountability committee, an economic advisory committee in the past. We also had the area commissions. We may want to add some additional language there that would specifically call out some of those organizations or creations of the commissions that are very specific, so that it wouldn't be subject to and open to interpretation, but could be more specific to allow us to definitely include them as a public body and have open meetings in the future. So if you were to allow us to go ahead and think about that as an addition to, as an amendment to put in front of you, that may be additional language we may share with you for your opinion.
Yeah, sounds good. Any other comments, questions, concerns about what we want to accomplish in this area? Okay. Thank you.
We probably can't put in the charter that the caucuses of the state legislature be open meetings, Ken?
Just one more reason why we need a change of leadership in the General Assembly. If there's nothing more on public records, the next category for discussion is an overview and discussion of ethics provisions.
I'll provide a sort of a very brief summary of ethics provisions in the Ohio Revised Code and our charter. We'll obviously defer to Josh Cox on any legal questions regarding the application of these. So, Ohio law addresses a broad range of ethics issues for elected officials and employees, ranging from financial disclosure for specified officials to theft in office and unlawful interest in public contracts. The Columbus Charter also includes specific provisions regarding these issues. However, those sections do not apply consistently to city officers and employees, and there are also internal consistencies in areas where the Charter does not mirror but does not conflict with current Ohio law. General laws of the state address the following specific ethics issues, and I'll list them by topic but not by ORC section. Financial disclosure, conflict of interest, revolving door regulations, public contract prohibitions, soliciting or accepting improper compensation, bribery, theft in office, unlawful interest in public contracts, nepotism, dereliction of duty, and interfering with civil rights. In addition to these state law provisions, the Columbus City Charter addresses the following. The first, in Section 6, is a prohibition on council members having an interest in the profits of emoluments of any contract, job, work, or service for the municipality. The second is in Section 157. That's a prohibition on abuse of political influence. And then in Section 227, unlawful interest in contracts or supplies. Of specific interest to this discussion today are Section 6 and 227 of the Columbus City Charter. So under current charter provisions, council members, but no other officials or employees of the city, are prohibited from having an interest in the profits of emoluments of any contract, job, work, or service for the city of Columbus. The archaic phrase, profits of emoluments, and it probably, as Josh has mentioned before, should be profits or emoluments, simply refers to wages, fees, or other compensation arising from the aforementioned. Presumably, this section does not apply to payment for employment as a council member, although that is not expressly stated in the charter. This requirement appears in the qualifications section regarding council members. As a result, council members and only council members must comply with this section as a condition of holding office. Section 6 provides two avenues to address violations. Council may void the contract for which a council member has an unlawful interest. And if the person has violated the section, that council member must forfeit office because they no longer possess the qualifications of office. I would note that council's permissive ability to void a contract does not mirror, but does not conflict with current state law, which provides that unlawful interest in a contract serves to render the contract void and unenforceable. Section 227 presents a very different prohibition regarding contracts for elected officials and employees. It says that no officer or employee of the city shall have any beneficial interest, which interest accrues to the employee or officer by virtue of office or employment in any contract with the city or in the sale to the city of any supplies, materials, service, or land, except on behalf of the city as an officer or employee. Any willful violation of this section shall constitute malfeasance in office, and any such officer or employee shall thereby forfeit office or employment. So under this section, a violation would serve to forfeit the office, and under state law would void the contract, although state law does not prescribe, as I could find, the mechanism for action for voiding that contract. Unlike state law, the charter provision does not extend to immediate family or business associates of city officers or employees. However, this less inclusive language would be permissible. For council members, a contract violation would not require the beneficial interest to arise from a willful, knowing, reckless, or negligent action. They simply have to do it. For all other elected officials and employees, the violation requires willful action according to the charter. In both instances, state law provides some additional protections regarding unlawful interest in contracts, conflicts of interest, and improper compensation. Staff will, in future meetings of this commission, address the other charter provisions regarding ethics and will expand further on issues in Section 6. So in conclusion, while our charter, together with state law, offers a great deal of protection against using public office for private gain, our charter provisions do not extend fully to all elected officials. They don't mirror state law in at least one regard, and they don't provide to all elected officials the same standards for a violation. However, Section 6 of our charter arguably provides more succinct, direct, and ironclad protections for the public interest. Based on the foregoing, staff would recommend that this commission consider the following. Should Section 6 and Section 227 be harmonized? Should council action to void a contract be mandatory, since state law automatically voids such a contract but does not prescribe the mechanism for municipal authorities? And then, could Section 227 be improved upon by expressly incorporating state law, by adding a mechanism for voiding a contract, and considering the expansion of these provisions more broadly, once again mirroring state law? And with that, I'd be happy to take any questions.
I'm one of the slower members of this commission, but I'm assuming that implicit in these three questions, the sense on the other side of the table is yes, 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 pretty much.
I think, I'll speak only for council, that I think that there's value in at least reviewing this language, reviewing the state law provisions, determining, first of all, with the city attorney's guidance, whether the current charter provisions are advisable, necessary, or if a simple reference to state law would suffice. I think that we at council are open to that discussion, but we do see some merits in maintaining some of the additional and stronger protections that are currently in the charter versus removing protections that currently exist for the benefit of the public interest.
I think the mayor and the administration are interested in reviewing this further and looking at some other options, as well as specifically referring to state law and using that as our guideline. So I think that once we get your blessing to move forward, once we get into more of the weeds of the actual language, we'll be able to come up with something good to share
Josh,
with
the city
you.
attorney's office is in harmony with those sentiments?
Well, I guess when it comes to ethics law, our position is, in general, consistent with our general statement that if it's covered by the general law of the state, it doesn't, stuff that's in the charter that's not the same as that should be either repealed or just reflect adherence to general state law and ethics law. Is there there's 2141 is broader than section 227 of the charter currently. So in effect, the charter provision is inoperative because you have broader provisions. It does, with one exception at the end of forfeiting office, but it's already, if someone commits has an unlawful interest in a contract, that's going to be addressed through state ethics law, not the city charter.
Yeah, I had a conversation with Mr. Clark about this, the references to elected officials not having other jobs or employment. I pointed up a couple of examples where I know esteemed members of the city attorney's office in past years have been invited to teach some law courses at different law schools. I myself was invited to teach for 21 years at Ohio State, and the only thing they would trust me with, government accounting and finance. I'm vain enough to think that we made some contributions in those efforts. So I don't, as I said, I haven't done that for a few years now, but I don't want this to be so broad that others and my successors, Josh and his colleagues, would be prohibited from that. Maybe I'm stretching it too far here, I don't know, but I just want to be careful about that. As I said, they sound vain, but they sought us out. We didn't necessarily seek the job, so to speak, so.
Reactions by the commissioners?
And for the commissioner's knowledge, at this point, the charter only prohibits the mayor from having another job.
And in our discussion, and I appreciate the auditor's recommendations there, this would apply only to other employment with the city. So other interest in or benefit from employment with the city in addition to a service or a contract with the city. So this specific section would not apply to outside employment.
Are you referring to section 6 or 227?
Section 6.
It says hold any other public office.
Mhm.
So would that mean elected office only? So that would not cover a teaching opportunity, even with the state institution, because that's not a public office, correct?
In your case, Hugh, I think for some years you served as a board member of one of the state pension funds.
Police and Fire Pension Fund for 20 years almost, I was a board
I'm
member.
assuming that's a public office, I would
I
assume.
would think so, yeah, I would think so. It's an unpaid, non-paid thing, but yeah, I would call that a public office.
I would say, coming upon the auditor's comments, I mean, certainly vanity is not the right word, for a city official, be it auditor or attorney or council member, or in my book, even the mayor, to have the generally recognized expertise to teach a course at a college or university, to do something else, which clearly is not in a conflict with the city employment, but quite frankly is a testimonial to that person's abilities and knowledge and education, is certainly something we want to encourage and never discourage. So I would share Hugh's concerns that whatever language we adopt be clear, that would never attempt to discourage that type of ancillary employment, if you will, which only adds to the credibility of those city officials. I guess what I would want to ensure is that if we are stating in the charter, making sure the charter conforms with the revised code in terms of ensuring that city council members have no interest in, have no conflicts of interest in city business, and certainly that ought to be across the board for all city officials and not just city council members.
And that would be one of the items that we look forward to addressing as we get to city officials. It's something that we've begun discussing here internally, just to sort of understand exactly where we might want to be looking in the charter to harmonize provisions.
It seems strange that this is in the qualifications for council members section, when in fact, it really won't come to play until after they've been elected to council.
Just to make sure that I understood one of the questions or conversations that was happening, there was a suggestion that potentially a pension board member could be considered holding public office. Was that a comment that was made? I just want to make sure if we use the terms public office that.
Well, I think I served I was appointed to the board of the Ohio Police and Fire Pension Fund by Governor Jim Rhodes. And I was very, very flattered, and I was reappointed by, I think, 3 different governors and for almost 20 years. So in my view, that's a public office. I filed the financial disclosure statements and all that kind of stuff. It was a non-paying position. But if I remember correctly, I think at that time, the Ohio Code even designated that one seat would be a municipal finance officer or something to that effect. I don't remember the exact word. I would hope that we would not preclude someone in this field from serving.
Okay. We'll definitely have some more conversations about that language and the definitions that could be used to make sure that we don't prohibit that in the future.
And that's a perfect example of where state law, there are a number of attorney general's opinions on compatibility of public positions, and where state law has changed over the years. It used to be public office or employment, and they eliminated employment, so it's just public office now. So there's been changes, not just interpretations, but different changes in that state law over the years. So I note that the qualifications provision, I think was in the original charter, 227 came around in 82, I think. So they didn't, I don't know if they thought to maybe take that provision out of Section 6 in 1982 or not, but in any event, that's part of the problem of putting stuff in the charter that is addressed in existing statutory law.
And then to your point, Commissioner Member Cabot, that we will look at how that's labeled as whether it's a qualification or a term of office. Thank you.
Have we had instances in your recollection where some appointing authority at the state level, at the county level, or at some multi-jurisdictional level wanted to appoint a city official to serve in some capacity, and because of existing charter provisions or other provisions they weren't able to serve?
Well, it's come up, which the only reason I know anything about it, it's come up. And it was one of those that wasn't clearly a public office, and but it was public employment, so you have to look at the compatibility of public positions, decisions from the Attorney General's office, and apply it and see if our charter has any specific provisions on it. So it's not a simple process, unfortunately. But I think, I can't remember what the actual answer was in the one that we reviewed on that, but came up not too long ago, so within the past couple of years.
I don't have this memorized, but I believe there's a section in our city code that allows city employees to run, is it for school boards, so long as they're not in direct conflict with the city and so forth. So there is a recognition that city employees can serve in some way. In that case, it would be a minimally paid type of arrangement. I don't know what they get, but
Although I think they're not allowed to serve on central committees of the parties, are they?
correct. I think you're right.
And that's a city code provision?
I think it is.
Political activities.
161.
I think, correct me if I'm wrong, members, but I believe it's a sense of the commission that we would not want to diminish the opportunities that city officials have to serve their communities and serve their state, as long as it's not a clear conflict of interest. We want to show off our abilities, if you will, and let people operate to the full extent of their aptitude and experience and talent.
Yes.
It just seems that Section 227 is under miscellaneous provisions, and that this issue might be important enough to, and I know that the titles really aren't part of the code, it's just for organization, but perhaps we ought to have a section or a title or something that says ethics, conflicts, whatever, and try to sort through all these various places where those things come up and try to state as directly and succinctly as possible with citations to state statutes, the best way of setting what the ethical considerations of conflicts are for all city employees.
It's a great idea. We can work on that.
I echo that sentiment. The only thing I would add regarding your question regarding creating some mechanism to void the contracts, by operation of law, they're void. So I don't think there's a need to do that, because once you identify that there's been this breach of the ethics law, the underlying contract is the source of the breach is then automatically void. As you are, I'm sure, aware, most contracts will put language in that says if any section is declared void, you hope to be able to extricate that section and keep the rest of the contract. But in the circumstances such as this, you wouldn't. The entire contract would just be void by operation of law. So because it just is, I don't know if there's a need to put in language as the steps that need to be taken to void it, because it's automatically void. So that's the only thing I would add related to that question.
Yeah, I agree with that. And it's one difference between the charter provision and 292141 is 292141 is a criminal statute, so you have to have the underlying conviction for that unlawful interest in the contract, which then triggers the voiding of the contract. So you have a standard and a judicial determination that then results in that consequence.
I think we're in agreement that the bullet points that you lay out here on the final page of the ethics discussion is something we'd like to see some language on. Any other thoughts before we close out the discussion on ethics? If not, we're on to item E, which is equal rights and non-discrimination. And is that you, Brian?
Beg forgiveness of the commission because I got a little wordy in this one, so sorry. So openness and inclusion are fundamental values for the city of Columbus. Our city has the second highest number of highly skilled new Americans, including Somali, Latino, and Asian communities in the nation. Our community's commitment to the LGBT community has earned multiple Best City rankings. Our city is a top 10 location for women entrepreneurs, and our community offers one of the best places in the nation for African American families. The Columbus City Codes reflects this openness and inclusion, providing many protections against discrimination. But these protections are still a work in progress, and the hard-won progress may be amended or repealed at any time by an ordinance. Difficult as it may be to imagine, this very thing has happened in our collective lifetime. How then should we approach public policy issues that address core values and fundamental rights in our community? Because of the history of piecemeal constitutional protections and legislative actions, and the instability of protections based solely on legislative action, staff recommends that fundamental rights such as equality and non-discrimination may be appropriately addressed in the Charter. Our nation, states, and cities have long struggled to fully assure political and civil rights for all. Too often, the struggle's history has been one of fits and starts at the legislative level and piecemeal provisions in our founding documents, leaving too many people hidden in the long shadow cast by discrimination based on race, sex, sexual orientation, gender identity or expression, color, religion, ancestry, national origin, age, disability, family, or military status. In the absence of an unambiguous declaration of rights and prohibitions on discrimination in the U.S. Constitution, the fragmentary process of protecting the rights of all Americans continues to this day. In 1787, the U.S. Constitution placed in the hands of the several states the right to establish voter qualifications and apportioned representation in Congress and direct taxes by adding the whole number of free persons, including those bound to service for a term of years, but excluding Indians not taxed 3/5 of all other persons. After ratification of the U.S. Constitution, only one state, New Jersey, allowed women to vote. The New Jersey State Constitution extended the right to vote to inhabitants, which allowed the New Jersey Assembly to pass a law expressly allowing suffrage for women in 1797, only to rescind that right in 1807 as payback for a political loss. The lack of clear protections in the state's constitution allowed one political leader to use the power of the New Jersey Assembly to disenfranchise half of the state's population. Ohio's first constitutional convention did not seriously consider universal suffrage. Over 100 years later, during the 1912 Ohio Constitutional Convention, an amendment to extend the suffrage to women was proposed but was rejected by the voters. Ohio did not remove its archaic and discriminatory exclusion of women from voting until 1953. The first U.S. constitutional amendment to abolish discrimination based on sex was proposed in 1923, shortly after ratification of universal suffrage. The Equal Rights Amendment was introduced every year for 49 years. In 1970, Shirley Chisholm, the first African American woman elected to the U.S. House of Representatives, reintroduced the Equal Rights Amendment. As that great unbought and unbossed leader said in 1970, federal agencies and institutions responsible for the enforcement of equal opportunity laws need the authority of a constitutional amendment. The 1964 Civil Rights Act and the 1963 Equal Pay Act are not enough. They are limited in their coverage. Evidence of discrimination based on sex should hardly have to be cited here. Its elimination would involve so many changes to our state and federal laws that without the authority and impetus of this proposed amendment, it would perhaps take another 194 years. We cannot be parties to continuing a delay. The time is clearly now to put this House on record for the fullest expression that equality and opportunity which our founding fathers professed. They professed it, but they did not ensure it to their daughters as they tried to do for their sons. After 49 years of advocacy, the Equal Rights Amendment was passed by Congress in 1972. While Ohio joined 35 states in ratifying this amendment, it was never ratified by the required 3/5 of all states. To this day, legislation like the Lilly Ledbetter Act attempts to chip away at sex discrimination due to the lack of this constitutional protection. Ohio has an equally checkered history of extending civil and political rights to African Americans. Ohio's first constitution, adopted in 1802, limited voting rights to white males 21 or older who owned property, paid taxes, or worked on roads. During the state's constitutional convention, suffrage for African American men was defeated by a single vote. Despite these provisions, John Mercer Langston was elected a Lorain County Township trustee in 1855, winning an office for which he could not even vote. Mr. Langston was the first African-American elected official in the United States, a full 25 years before the 15th Amendment began the long process of extending the franchise to all Americans. In 1912, Ohio voters rejected a Constitutional Convention recommendation that the word white be removed from voter qualifications. 11 years later, voters approved the removal of the word white in the Constitution. 97 years after all Americans earned the right to vote, the 24th Amendment of the Constitution banned the poll tax, one of many egregious attempts to block equal access to the ballot. To this day, partisan wrangling over voting rights and restrictions at the state level demonstrates the limitations of that and other amendments. We've previously noted here that charters reflect the unique social, political, cultural, and economic histories of their city. While charters may address some issues that are purely local and temporary, charters also address issues that will remain both universal and relevant because they relate to challenges inherent to local government. The Columbus City Charter demonstrates these straightforward facts. Like many charters of the early 1900s, ours was focused on combating the political spoils system, corrupt ward politics, and the lack of checks and balances in city government. In response, citizens of Columbus adopted a progressive city charter, which included the following provisions: a civil service system for city employment, including specific protections against undue political influence and discrimination based on political beliefs, a legislative body elected by the entire city and accountable to every citizen, along with the provision for the initiative, referendum, and recall, and a separation of municipal powers among the mayor, city attorney, city auditor, and city council, all elected in nonpartisan elections. The framers of our charter were wise enough to provide a framework for addressing these enduring political problems, and that framework remains necessary as we see in political scandals throughout the country. While our charter got it right in many regards, our city is not afforded the same civil rights protections that the framers provided for political rights. Like the Ohio Constitution of 1912, the Columbus City Charter adopted in 1914 did not recognize universal suffrage. However, Columbus voters did remedy this exclusion by a charter amendment in 1917, 3 years before universal suffrage was amended to the U.S. Constitution. Other civil rights protections came much later. The city enacted a protected class employment anti-discrimination code in 1971, covering race, sex, religion, color, or national origin. Despite gains for women, African Americans, and veterans, protections for the LGBT community lagged. In 1973, Council adopted an ordinance expanding and updating the discrimination-protected classes to include race, sex, religion, color, national origin, sexual orientation, and veteran status. Former Mayor Tom Moody vetoed the ordinance, stating at the time that it contained a drop of poison. He was supported by then City Attorney James Hughes, who stated that the ordinance promoted homosexuality and would cause problems with police and fire department. That same year, the LGBT activists filed for the first of 18 permits to march on West Broad Street, all of which were rejected. In 1974, Council adopted a less comprehensive ordinance that, for the first time, extended protections against discrimination in housing and public accommodation based on sexual orientation. In 1981, Stonewall Union, now known as Stonewall Columbus, held the first Pride Parade in Columbus. Of the hundreds of participants, many were so justifiably fearful of attack, discrimination, and intimidation that they wore bags over their head in the march. In January 1984, just 3 years later, former Mayor Dana Buck Reinhardt issued an administrative policy banning discrimination in city employment based on race, color, religion, national origin, sex, age, ancestry, handicap, or Vietnam-era veteran status. That same year, Columbus City Council voted down an ordinance that would have banned discrimination in employment based on sexual orientation. 6 years later, Council recreated the Community Relations Commission over former Mayor Reinhardt's objections. For the first time that staff could identify, the ordinance established in City Code protections against discrimination in city services based on race, color, religion, national origin, sex, age, marital status, political orientation, sexual orientation, or handicap. On December 14, 1998, Columbus became the first city in Ohio to offer domestic partner benefits for all city employees. Within 2 weeks, a referendum led by a local Central Committee member and an anti-LGBT activist was underway. In less than 30 days, the group collected 10,023 signatures on referendum petitions. The board validated 8,400 signatures, requiring council to either repeal the legislation or put it before a vote. Less than 2 months after passing this historic ordinance, council was forced to repeal the legislation. Had the repeal effort been successful, all future consideration of equal benefits would have required approval of the ballot box. Thanks to Mayor Michael B. Coleman, limited domestic partner benefits were offered administratively beginning in July 2nd, 2004, though the city did not pay any portion of the premiums. These benefits were later extended by ordinance of council to all city employees in 2010, 12 years after the first ordinance was passed. In the intervening years, council has passed multiple ordinances expanding non-discrimination to additional protected classes. Yet the city code is still not wholly inclusive, and the city charter does not address civil rights protections. A review of the nation's 30 largest cities, along with Akron, Cincinnati, Cleveland, Dayton, Toledo, and Youngstown, reveals that 22 cities have directly addressed equality or non-discrimination in their charters. These 33 separate charter provisions vary widely from prohibitions on discrimination in housing or contracts to a full declaration of political and civil rights. While most reflect historical reactions to local issues, more recent charter amendments, such as that in the city of Detroit, attempt to address the issue fully. Cities that fully address equality and non-discrimination tend to focus on two core governmental functions: access to city services and city employment. In both instances, a city's officers, employees, contractors, and agents are prohibited from denying access to city services or equal opportunity employment on the basis of a specific set of protected classes. Much like the city of Columbus, cities with more comprehensive charter provisions address discrimination based on race, sex, sexual orientation, gender identity or expression, color, religion, ancestry, national origin, age, disability, family, or military status. These cities provide a clear precedent for charter-based protection of civil and political rights, especially in light of inadequate state laws. As Harvey Milk, the most famous and significant open LGBT official ever elected in the United States, said, "It takes no compromising to give people their rights. It takes no money to respect the individual. It takes no survey to remove repression. It does, however, take action." The city of our nation, state, and city demonstrates the volatile and often incomplete nature of legislative, civil, and political protections, while there's ample evidence that other cities address equality and non-discrimination in their charters as a result. We understand that no city ordinance or charter provision can change hearts or minds, but our charter can reflect our fundamental value of equal protection in the most permanent form available to our local government. Unlike an ordinance or resolution, a charter provision assures that only a vote of our citizens can alter the fundamental ideals of equality and non-discrimination that make us an open and inclusive city. Based on the foregoing, staff suggests that this commission seriously consider recommendation of an equal rights and non-discrimination amendment to the charter of the city of Columbus. And with that, I'm happy to answer any questions.
Reactions, questions of commissioners?
First, Mr. Clark, I'd just like to say thank you for this comprehensive overview. It was very helpful to see this history, some things that we can be proud of and some things maybe not so much. And I would just like to say that I wholeheartedly support staff's recommendation for the inclusion of such an amendment. And Mr. Chair would be happy to make a motion if appropriate.
Other reactions, comments?
Let me ask, have you submitted some recommended language? I'm paging through all the...
No, at this time, we've not submitted recommended language to the
Not to the
commission.
How comprehensive has the staff's review been of what language has been adopted in other city charters?
Very comprehensive. We have a spreadsheet that you'll find here that lists by category the type of protection that's afforded in these other cities. It ranges from protection in housing, public lodging or accommodations, city employment, city services, and then other. Generally, where you see other, that's a comprehensive approach to non-discrimination and equality. Generally speaking, these cities address non-discrimination to a set of specific classes and address it in the areas of city employment and in the area of city services, because those are the two areas where the city would have the greatest control. It is worthwhile to note that based on Ohio law, protected classes like sexual orientation would not be protected without city code or our charter.
And as Brian shared during his speech here, his comments, I said his speech, his comments, sorry.
It was a speech, it's all right.
I'm sorry. We do have various code provisions that we've been working on. So we do have language that we continually update and change, and in fact are working right now with the city attorney's office and our community relations commission to work through some new language in our recreation and park section of our code. So I think we do have a lot of foundation of where we want to get, and we think it's important enough to take that message from the code and place it in the charter. So we do have that foundational language that we'd like to just really start to elevate.
And I believe
I would agree.
Josh, comments from the city attorney's office?
No, the only tricky part of this is getting the class of individuals who are protected in a way that you don't have to, and you can go back and amend an ordinance easily. Amending the charter is more difficult, so that's the only tricky part in writing this language.
Josh, for that, would we be able to, though, supplement it by adding something in an ordinance later? But, I mean, if we had something in the charter that set out X, Y, and Z, could we add in A, B, and C later by ordinance?
Right, I think it's just making provision for that type of,
Yeah, the three things that we've looked at most closely are protections in access to city services, protection for city employees, and then a provision that would allow us to recognize additional classes as they are recognized either at the state, the federal, or at the local level, so that we would not have to go back and amend the charter as a result.
Let me ask, I want to make sure I understand what you said, Brian. Otherwise, the state code is not as inclusive. Repeat that for me, please.
Our state code is not as inclusive as our city code. So if council, this council would not, but if council were to repeal all protections in our city code, there are protected classes that would no longer have protection in public accommodations, housing, or employment because of the current state of Ohio
The
law.
state code does not address those particular.
It does not fully address the protected classes that we address. That's correct.
I think it would be helpful for the commission to see at your earliest convenience some of the language of these other city charters that you think are well-crafted, that would likely inspire some of your own wordsmithing attempts to get to the goal here. And I think, as I listened to the historical summary, which was very good, I'm thinking as, federal courts across the land are beginning to strike down a lot of discriminatory laws. I mean, I think, correct me, Josh, I'm practicing law without a license here, which I'm perpetually guilty of, but it's the Equal Protection Clause of the U.S. Constitution, which is the bedrock for those decisions. And it would be nice to have a city charter corollary, if you will, to an equal protection clause that's already in the U.S. Constitution. Obviously, it'd be broader in its express wording, but something which would, I think, call upon the federal equal protection clause, would be something that would be well received.
I would add, it would be helpful for me to see maybe a spreadsheet, and this is to Auditorian's point, that the city code is more inclusive than the state law, to see what the state law, what current protections the state law offers, and where the city of Columbus has gone above that, just for comparison purposes as we look through the language that will be proposed.
Brian, from your review of the literature on what other cities have done in terms of fairly recently, I presume, adopting these types of charter amendments, has there been much litigation? Has there been much override attempts? Has there been a lot of community activism, debate over either intended or unintended consequences of this expanded language?
Not that I've identified as I've reviewed these provisions. Probably the most recent would be the City of Detroit, which has a fairly significantly updated and I would argue well-crafted charter that's been adopted. It includes something that most Ohio charters don't, but other states do, which is a Declaration of Rights, which is essentially a city Bill of Rights as a preamble to their charter. And this is something that's addressed there and then addressed throughout as a provision. It does in Detroit, which again is probably the most comprehensive example. They include an affirmative duty that the city protect the political and civil rights of its inhabitants, and then go on to put these specific items in. And while I'm not making that recommendation to this commission, it is something that other cities have done.
So the ask of the commission today is simply to proceed with some language refinement and proposals?
And we'll have some additional research available as you've requested. And I would say probably the simplest and easiest would be to look at the City of Detroit charter. It's the most recently updated and probably the most comprehensive in this regard.
Any other reactions, questions, comments about this section?
I would only like to say at this time, if appropriate, I would like to second Commissioner Tyler Lee's motion that was on the table to ask staff to go forth and prepare the language.
Any other discussion on the motion? If not, all in favor?
Aye.
Thank you. And again, thank you for the excellent staff work to prepare us for today's meeting. With that, the announcement of future meeting dates.
I believe that we provided you with and I apologize, I don't have it in my documents here in front of me.
I do.
It is off of John Ivanik's printer, so I can't guarantee it's correct or readable.
The next and fifth meeting of the Review Commission will be Thursday, June 19th, from 1 to 3 p.m. The sixth meeting of the Review Commission will be on Thursday, June 26th, from 5 to 7 p.m., and that will be our second public hearing session. And the seventh meeting of the Charter Review Commission will be on Monday, June 30th, from 2 to 4 p.m. And there will be additional meetings scheduled after June 30.
And if I could, Chair Curtin, staff has reached out to the commission members. We have a lot of ground to cover, a lot of ground that we would like to recommend covering between now and the final meeting that we currently have scheduled. So there is the possibility of additional meetings between now and June 19th. And as those are made available, they'll be public noticed and sent out in the city bulletin as well.
At what time or what meeting will we have this list of, let's say, recommendations for us to see, and I use the word synopsize some way or another? Will that be at this last meeting, or will that be subsequent to the meetings that are listed? Am I being clear? Otherwise, we're going to have 10 or 12 or whatever number of recommendations coming forth, and when will we sit down and say, yes, we agree, this is the language, and we recommend it. What point
I
in
need some
time?
help in response to that question.
I think staff's recommendation, in keeping with Commissioner Cabot's comments about making sure the public has ample time to review these things, our goal would be that on or about the 19th, we'd be able to provide much of this for the commission's review, and then ideally adoption of final recommendations at that last meeting that has currently been scheduled.
Any other questions or comments? Even though this is not a public hearing, are there any questions or comments from the members of the public who have come down to attend today's meeting? Yes, sir.
Back to the executive session aspect we were discussing. My understanding is that the city council doesn't really have the reasons for executive session, so you go by the state, the ORC law, and go on that. Was that my understanding?
Josh, do you want to answer that?
That's current law.
I was just wondering, it was brought up, so I was wondering if there has been any kind of public input on executive sessions in terms of if the public wants some of the executive sessions or some reason that you have executive sessions to be public. Is there any discussion going on with that with the public?
I would say that's not a current proposal, that's one that was with the last commission.
Yeah, there was actually the most recent Charter Review Commission dealt specifically with bringing our charter, harmonizing it, and bringing it in line with current state law regarding open meetings, and that was subject to the vote of the people and was supported and amended to the charter.
I heartily support the equal rights and non-discrimination, and it was a wonderful document to hear. It would be nice to have that public.
It will be available on the website very soon.
I agree with her also.
All of the documents that are being presented to the commission are also being put on the website of the Columbus Charter Review Commission, which can be accessed through the City of Columbus website itself.
Thank you.
If there's no other input from our guests, thank you for your attendance. Thank you for the great staff work.
I would just say it would also be very helpful if we had the list of potential recommendations ahead of the public comment, just so we kind of knew the direction, so that would be helpful.
Well taken. With that, if there's no other business to come before us, I'll entertain a motion to adjourn.
So moved.
All in favor?
Aye.
Thank you very much, and we will be communicating with all of you before our next meeting on June 19th.